Afternoon, everybody. My name is Murray Hunt, and I'm the director of the Bingham Centre for the Rule of Law. And it's my great pleasure to welcome you all to this event, which we are co-convening with the University of Strathclyde and with the Bonavero Institute of Human Rights at the University of Oxford. And my great pleasure is to invite you to this extremely interesting and topical subject. The purpose of our event this evening is to reflect on the implications of the recent Supreme Court judgment, with which you will all be familiar, on the Scottish UN Convention on the Rights of the Child Bill, both for children's rights in Scotland and for the UK's devolution settlement, and to situate that all in the context of the wider journey that Scotland is going on in terms of its human rights development and framework. I had the privilege last year to be an independent member of the National Taskforce on Human Rights Leadership, which was co-chaired by Professor Alan Miller, which made a number of detailed recommendations about how the legal framework for the protection of human rights in Scotland could be improved. And the Scottish Government is committed to implementing those recommendations and will shortly be launching a consultation on a new human rights bill, which will be incorporating a number of so far unincorporated human rights treaties into Scots law. For those of you familiar with the consultation paper issued by the UK government in December on reform of the UK Human Rights Act, the direction of travel, it will be clear, couldn't be more starkly opposite. I'd just like to thank, before we start, the organisers of tonight's event, Lucy Moxham at the Bingham Centre, Richard Mackenzie Gray Scott at the Bonavero Institute, and Dr. Elaine Webster at the University of Strathclyde for their conceptualising this event and pulling it together. A little bit of housekeeping. We are recording, as you will have seen, and the recording will be made available. We've got two panels of speakers. Each panelist will speak for a maximum of 10 minutes, and I really want them all to keep to time. I will be butting in if they don't, because we only have half an hour, and we want to make sure that we've got at least 10 minutes of questions from participants at the end of each panel. The questions for the panelists, if you could please post those in the Q&A, and we will take those questions and you can vote on them as well, which proved to be most popular in the Q&A panel. So our two panels we've divided into one looking at the UNCRC bill itself and incorporation and children's rights in Scotland, and the second one looking at devolution, the wider constitutional implications, and the wider human rights framework in Scotland and its development. So I'd like to briefly introduce the first panel, if I may. We've got three panelists. Juliet Harris, who is the director of Together, which is the Scottish Alliance for Children's Rights. And she will be talking about the campaign for the bill, the provisions in the bill, and what it was hoped to achieve through the bill. Dr. Kasey McCall-Smith from the Global Justice Academy at University of Edinburgh Law School, who will be talking about the impact of the Supreme Court's judgment, what was lost, what remains, and how this responds to the incorporation efforts and delivery of the UN Convention on the Rights of the Child. And finally on this panel, our very own Michael Abiodun Olatokun, who is our research leader at the Bingham Centre in Citizenship and the Rule of Law and the head of Public and Youth Engagement. And he will be talking about perspectives of children and young people on human rights law, the value of the UNCRC, and its potential future incorporation in England. So I'd like now to move, please, first to our first panel and to Juliet. Over to you.
Thank you, Murray. I'll just get my slides up and running. Yeah, thank you so much for the introduction, and just delighted to be here at this very timely event. Yeah, I'm Juliet Harris. I'm director of Together, the Scottish Alliance for Children's Rights, which is a membership organisation of civil society, charities, academics, professionals working to further children and young people's rights. We've been involved in pushing for incorporation of the UNCRC into Scots law for the last 10 to 12 years, and have a membership of nearly 500 members right across Scotland. So in my presentation today, I think if we're going to look beyond the UK Supreme Court judgment on the UNCRC Incorporation Bill, we should really kind of start at the beginning and look at the long journey that children and young people have played in Scotland in campaigning for UNCRC incorporation. Obviously, this journey began with the UN General Assembly adopting the UNCRC over 30 years ago in 1989. And since that time, children's rights have obviously become more well known, more accepted, not just in Scotland, but right across the world. But I would say the real point at which children and young people's journey in Scotland in campaigning for UNCRC incorporation began in around 2010, 2011 time. At this point, progress was being made in Wales with the Welsh measure for children and young people, through which a bill was introduced that places a duty of due regard on ministers in Wales to pay attention to the UN Convention on the Rights of the Child. Obviously, there's a kind of natural competition, friendly competition between Wales and Scotland, and this got Scotland thinking that we want to incorporate the UN Convention, make rights binding in Scots law, children's rights binding in Scots law. At that time, the Scottish Government introduced a consultation on Rights of Children and Young People Bill that was then put aside for Children and Young People Scotland Bill. But children and young people across Scotland started to think about incorporation and started to campaign for incorporation. And that was where really we began to understand in Scotland the power of making children's rights binding in law rather than something that we just needed to think about. In Scotland, we have very kind of vibrant organisations led by children and young people. And the Scottish Youth Parliament really adopted the campaign for UNCRC incorporation. And members of the Scottish Youth Parliament, alongside the Children's Parliament, took the campaign to their hearts and really pushed for it at a political level, but also in their communities. So in 2016, the Scottish Youth Parliament consulted with 70,000 children and young people across Scotland and found that there was really strong support for making rights binding in law. 76% of young people at that point wanted to make rights binding in law. So they launched a campaign right here, right now, to campaign for UNCRC incorporation. The children and young people from the Scottish Youth Parliament, from the Children's Parliament, have annual meetings with the Cabinet. So with the First Minister, with the Deputy First Minister, all members of the Scottish Cabinet. And at these meetings, they began as well to push for UNCRC incorporation, talking about the value of them knowing that their rights were things that people had to do rather than just think about. And children and young people have continued this campaign. They've led this campaign right up to the point of the 16th of March, 2021, so nearly a year ago, when they supported the unanimous passage. So every political party in Scotland agreed, supported the bill as it went through Parliament, and there was unanimous passage of the bill through the Scottish Parliament. It's a great thing about working with children and young people on campaigns like UNCRC incorporation is that it really makes kind of legal concepts like incorporation of rights into law fun and interesting and important to everybody across children and young people, but across communities as well. So looking here at what children and young people were saying at the beginning of the campaign, this is 2011, and you can see why incorporation is so important to children and young people. They talk about rights being binding in law, supporting a culture change. They say rights should be part of the culture of life. And certainly that is what we found from countries that have incorporated the UNCRC into law. Countries such as Norway have reported that actually they become more child-focused. They think about children and young people in all of their decisions. Children and young people talk about the importance of rights not being optional, things that people have to do. And so this is what children and young people were telling us over a decade ago. So it's important to reflect that these children and young people actually aren't children. They're not even very young anymore. They're all adults. And this campaign has been continuing ever since this point. Even reflecting on Human Rights Day in 2018, which seemed like a pivotal moment in the campaign for incorporation in Scotland, Ryan McShane, a member of the Scottish Youth Parliament, addressed the First Minister and actually challenged her to commit to incorporate the UNCRC fully into Scots law within that parliamentary term. So that meant incorporating the UNCRC before May 2021. Again, at that point, when Ryan was calling for incorporation, he was definitely a child, as per Article 1 of the UNCRC. He was 16 years old. He's now just recently celebrated his 20th birthday. So many of the people, so many of the children who've been involved in UNCRC incorporation aren't actually children anymore, but the campaign continues. The shape of the bill that was passed by the Scottish Parliament is really important. And again, it's something that children and young people were really supportive of and really keen to see. I sometimes call it a carrot and stick approach, because there were so many measures within the bill to actually take a proactive approach to children's rights. So it's very different in a way to the Human Rights Act, that it's got a children's scheme. It promotes awareness and understanding of rights. It promotes child rights budgeting. It promotes the use of child rights impact assessments. And these are all measures that help to ensure that rights aren't infringed from the outset. This proactive approach to children's rights was seen as really important to children and young people, because they don't want their rights to be breached from the outset, and they want to know about their rights. But we know from our experience from the Human Rights Act and from countries that have incorporated the UNCRC that the carrot alone isn't enough, and you have to have the stick. So there are provisions that are very similar to the Human Rights Act that enable children and young people to challenge breaches of their rights, to make sure that the Children's Commissioner is able to offer support if children and young people want to challenge their rights. Making sure that there's no time limits on proceedings, and so that children can continue challenging breaches of their rights until they're over the age of 18 years old. And so it's so important to have this carrot and stick approach to make sure that the mechanisms are in place to get things right from the outset, but ensure that children and young people have access to remedy and redress when their rights have been breached. And so what was our hope with the bill? Well, children and young people who were speaking to parliamentarians as the bill went through Parliament to help inform some of their deliberations and their scrutiny of the bill, they were telling us that their hope for this bill was that they would have power. It would help children and young people feel like they were able to do something if they were abused, if they weren't respected, if they felt their rights weren't being protected. Their hope is that the bill means that everybody knows about their rights, so they can recognise when they're breached and they're able to do something about it. And their hope as well is that this impacts on all areas of society. It's not just about education, it's not just about children's services. It means children and young people should be taken into account in all areas of decision making, from transport to environment, right across the board. So that was the hope as the bill was passed, that this was going to be the kind of Scotland that we were going to see. And like I say, it was nearly 12 months ago that we were celebrating UNCRC incorporation. And you can see here from the virtual celebration party that we had, our Zoom party, children and young people who'd campaigned for the bill were joined by the Children's Commissioner, by members of the UN Committee on the Rights of the Child, by parliamentarians. And we really thought that that hope was going to become a reality for children and young people. Of course, we're now 125 days, to be precise, since the UK Supreme Court judgment put a stop to this bill being progressed. We do have a commitment from the Deputy First Minister that Scottish Government want to use the reconsideration process in the Scottish Parliament to try and address the Supreme Court judgment in a way that ensures full and maximum incorporation insofar as the powers of the Scottish Parliament allow. But at the moment, I would say the impact of the judgment means that we continue to sit and wait and see whether the hopes and the dreams of all these people celebrating incorporation, all the people who've campaigned for incorporation, see whether they can actually be fulfilled. The bill passed again by the Scottish Parliament, and we really get on with the work of turning rights into reality for every child and every young person in Scotland. Thank you.
Thank you very much indeed, Juliet, and thank you very much for keeping to time. Your fantastic slides really demonstrate one of the really important things of the incorporation campaign in Scotland, I think, which was that it got children engaged in the political process as well, to incorporate their rights, which was, I think, looking at it close up, a really important effect as well of the campaign. Thank you very much, Juliet. So we can move now straight to Kasey.
Great, thank you, and thank you all for having me. I'm really pleased to be here today. So I'm going to follow on from what Juliet spoke about and talk a little bit about the bill, but predominantly about what happened after the Supreme Court judgment. Really, I'm concerned with what was lost and what remains, and I'm going to try to stay optimistic about what remains, because I think that's the important take-home message from the bill. You'll hear in the next panel about the constitutional niggling that's going to continue, I suspect, in terms of human rights incorporation from other panelists. But what I want to talk about is what happened after the judicial reference bill. So, as everyone I'm sure knows, the Scotland Act details that Scots law can't be incompatible with the ECHR, and that Scotland should observe and implement the UK's international obligations. So the further revisions of the Scotland Act have opened up the opportunity for Scotland to legislate across numerous policy areas, including education and training, health and social services, housing law, law and order, different aspects of equality, social security and taxation, and many of those aspects that are absolutely crucial to ensuring that children's rights are respected and protected. And so the UNCRC incorporation bill brought all of that together. And as Juliet noted, the stick and carrot approach was the approach that was ultimately passed in the bill. Now, I'm not going to go into the particulars of the bill. I'm sure people have looked at it. But I think what's important to note is what was challenged in the bill. And what happened effectively is that as soon as shortly after the bill was adopted, the UK government challenged a few of the sections 4 to be precise. So sections 19 to A2, which seemed quite simple. You could just remove the Act of Parliament in terms of the applicability of that section. Section 2010A2, which is the strike down option. Again, here you could just remove the Act of Parliament in order to make it compliant with the decision. And sections 21(5)(b)(2), which is the declaratory of incompatibility, again, removing the Act of Parliament. This is what was challenged because that was viewed as being in excess of the competence of the Scottish Parliament. I think more concerning for most people in Scotland after the very hard-fought battle towards getting those ex-ante obligations on public authorities was the challenge to Section 6. And the big problem here was it wasn't clear which public authorities would be required to comply with the UNCRC, and it was viewed that this on its face was deemed to exceed the competence of the Scottish Parliament, because it could very easily implicate those public authorities that were actually giving effect to Westminster made law. So these, in the context of the constitutional wrangling, I'm not going to go into because I'm not a UK constitutional lawyer. I would just make it more confusing. But I think what is important is what is left. As I said, with all of the different revisions to the Scotland Act, there are a wide range of powers that the Scottish government has and the Scottish Parliament can legislate toward that could still be read in compliance with the UNCRC and be delivered with the UNCRC in mind. And I think that these proactive duties on public authorities and on Scottish ministers to give account to the UNCRC is really important for many of those reasons that Juliet talked about, but a primary reason for driving culture change. And so anytime that Scottish ministers or anytime public authorities start to put the UNCRC at the forefront of their actions, it's going to engender culture change. And this is really important and was an underpinning feature of the bill. So while the judgment said that the bill needed to be revised, the main points of the bill remain intact, that the UNCRC, with the exception of the few articles that were deemed out with the competence already, such as in the context of 16 and 17-year-olds being drafted into the military, most of the obligations of the UNCRC remain intact. What is problematic is the enforcement, and that's that stick approach that is coupled with the ex-ante obligations. And I think it's easiest if we look at an example of how this might be different in Scotland if it is implemented and what we're waiting for it to be implemented. So I can show you how we haven't lost that much because there are always going to be areas of gray between the competence that exists between Westminster and Scotland, even with all of the copious amounts of legislation we have that fall under the devolved competence or in the reserved competence. There are lots of gray areas, and there always have been, and I suspect there always will be under the current constitutional settlements. So one of the key and hard-fought battles in the UNCRC bill was the interpretation section under Section 4, which sets out that there are numerous sources of interpretive materials that courts should rely upon when they are determining whether a question before them is compliant with the UNCRC. And this includes obviously the UNCRC itself and the 2 optional protocols, but it also extends to general comments. It extends to concluding observations that have been made in the context of the UNCRC. It extends to the days of discussion, which is unique, one of the unique features of the UNCRC and the Committee on the Rights of the Child. And so what's important is that the bill ensures that these different interpretive materials are used in terms of assessing the obligations of the government, the public authorities, and different questions of law in the context of the convention. And so one of the ways which I think this will still, regardless of what's been taken away, represent a tide change for children in Scotland is the way in which we interpret questions of law. And I'm going to use an English case from last summer, the decision by the Supreme Court in R on the application of AB versus the Secretary of State for Justice. The Supreme Court decision came down last summer. And this question concerned the exclusion of a 15-year-old at a English Young Offenders Institute for 55 days, which is technically solitary confinement. And the question before the court was whether this breached ECHR Article 3. And this may seem a bit of a random case to select because it's an English case. However, if we look at the definition of solitary confinement, that is the physical isolation of individuals for 22 or more hours a day without meaningful contact. Now, the Scottish government has already committed to doing away with solitary confinement and, in fact, imprisonment of children in young offenders institutes in Scotland. But in this English case, the question that was before the court was whether this was problematic in the context of the ECHR, and it found that the European Court of Human Rights had not ever determined that a child couldn't be held in solitary confinement, and that's true. But no case has come before it thus far about children in solitary confinement. And it also determined, in fact, Lord Reid went to great great pains to clearly outline that all of the existing international standards regarding solitary confinement of children weren't necessary to be considered in the context of this case because they weren't incorporated into British law and because there were no definitive judgments from the European Court of Human Rights. And so what I think is important to point out is that every single medical association, psychiatric association, international legal expert group on children's rights has clearly said that solitary confinement should never be used in the context of children. The CRC's interpretations of the UNCRC prohibition against torture and cruel and human degrading treatment says solitary confinement should never be used against children. Not just for 22 hours a day, so not just for one day, but never. And in the context of this case, it was 55 days. And so the value of having the UNCRC incorporated, and what I think is the knock-on value for other human rights, is that if the UNCRC bill was effective, and this case had happened in Scotland, then the court would have been required to consider those interpretive materials. While they're not binding, I think the overwhelming evidence from international standards and indeed the interpretations of the UNCRC would have led the court to find differently, and that solitary confinement indeed would have violated Article 3 of the ECHR, because the ECHR and the European Court, and often the UK Supreme Court, has already utilized the UNCRC as an interpretive tool when looking at the ECHR because of the specificity with which it deals with children. So I think the point that I want to make in closing is that the obligations that are set out in the UNCRC are going to be a benefit to children. And even if we have this disconnect between what has to be removed in order for the Scottish Government and the Scottish Parliament not to exceed its competence, there still is so much valuable human rights and children-specific rights that remain, that regardless of those things that have been taken away, the culture change, the proactive consideration that government authorities will have to give to children's rights, and the entire convention will no doubt make Scotland the best place for children to live in the United Kingdom. Thank you.
Thank you very much indeed, Kasey. Your comments there put me in mind of Conor Gearty's recent very interesting piece in the London Review of Books, which was rather excoriating about the current Supreme Court. And one of his interesting criticisms is that his view is that lived experience is not very central to the jurisprudence of the Supreme Court at present. And I think a lot of your comments just reminded me that actually incorporation of UNCRC does provide many avenues for the lived experience of children to come before courts more easily, and with the effects that you pointed to in terms of likely outcomes. Thank you very much indeed. If we can move now then please to Michael.
Hello there everyone, thank you very much for having me. So I've been asked to address the topic area of the potential incorporation of the Convention into English law, as well as the sort of impact of this in the sense that young people desperately want it, and wider considerations about how this might affect civil society. So the first thing I'd like to do is to focus on civil society. I feel very emotive about this topic because I remember a few moons ago, I was a member of Youth Parliament, and one of the campaigns that the Youth Parliament has traditionally stood for is the incorporation of the UN Convention into domestic law. And I and many others did a series of surveys of local people throughout our areas, and time after time, year after year, through that area, English young people have repeatedly said that the Convention on the Rights of the Child is something that they're very interested in seeing happen. And in the last exercise, 70,000 English young people said that they would want that to happen in a time when it was quite difficult to collect survey responses as a result of the pandemic, as these things are usually done at school by their local member of Youth Parliament. So they're incredibly popular, these notions. And I think my first sort of experience as a professional, where I first started to consider actually maybe it might be quite a useful thing to have a full incorporation of the UNCRC, is when I was working with a campaign group in Nottingham. And this campaign group surveyed all of their members. They had collectively about 10,000 members, about what the biggest issues in the city of Nottingham were. And the two things that came up were 16 and 17-year-olds who were presenting as homeless, not being given sufficient immediate accommodation by the local council, and the quality of private sector accommodation. And on that first issue, there was a judgment from the, at the time, House of Lords that interpreted part of the Children Act of 1989 that in essence was very, very helpful for that campaign group. The legislation, to summarise a very complex issue, essentially said that if somebody presents as a children in need, they have to be provided with immediate accommodation by their council's Children's Services Division, that being the case of G and Southwark 2009. And the provision of the Children Act that was used was relayed by me and another lawyer in a sort of presentation that we did with the lead portfolio member for housing. And the impact of that is that the City Council then changed their approach so that they would provide immediate accommodation to an older teenager who did present as homeless in the city. Now, I say that because obviously the Children Act is law and indeed has been for quite a while, but I believe it's been taken as far as it can, and the existing other principles in the CRC that are not recognised in domestic law might well need to be brought home. Talking about G and Southwark in a bit more detail, this is a piece of domestic legislation that had a secondary interpretation by our senior courts that then influenced the downstream behaviours of local councils in this country. And we as a campaign group were able to see this particular issue that children are supposed to have as a legal entitlement is not being recognised, and that judgment, the legislation, and the fact that a court had to consider it were incredibly useful in us being able to turn things around for those children and young people. So on that point, incorporation of the UNCRC would provide a domestic cause of action in a situation of judicial review, and that can often have an impact on loads of children and young people at once. The second impact I'd like to discuss is the culture that legislation of this nature creates. In what I think is one of the best textbooks about government and politics, Duncan Watts describes what he calls a human rights consciousness culture that has been fomented and encouraged by the Human Rights Act. In his view, the international treaties operated at one level in making human rights a kind of thing that's in the common lexicon, but the Acts took it to a whole nother level, whereby because individuals knew people who were able to bring human rights cases or had themselves been told about the legislation, they were much more confident and able to understand how that works in principle. At the Bingham Centre, we've been running a programme, a public and youth engagement programme, where we're trying to help young people to understand their rights in order to be the best possible functioning citizens that they can be in society. And in that work, we gave evidence in 2017 to the Ad Hoc Select Committee on Citizenship and Civic Engagement. The final report of that committee had some quite damning things to say about the state of children's rights more broadly and citizenship education specifically, such that they said citizenship education in this country is in a parlous state, and that it is impossible to tell whether a given young person is sufficiently knowledgeable about politics to be able to do those things as an adult. The reason why this might be significantly improved by incorporation of the convention is the reaction from civil society whenever such a thing is created. You see organisations, educational institutions pop up. You see funders who are prepared to support people, who are telling people about rights. And we see that sort of activity shaping civil society and has shaped civil society since the passage of the Human Rights Act. And I believe that it could have a similar impact on the children's rights space. One of the things that we've also been engaged in is a working group of predominantly English organisations who are working with the Department for Education and other governmental stakeholders in order to help with the wider general comments that the UN Committee on the Rights of the Child give periodically in respect of the UK government and how well children's rights are working. The reporting cycle, I believe, is something like a 5-year cycle. So we experience quite a high latency between the UN committee acknowledging that the UK is facing a problem and the government being asked to report on their progress with such an issue. That realistically is the kind of time frame in which large, widespread issues, projects, developments that affect all young people are going to be meaningfully resolved, from identification of an issue to the resolution of an issue. It's my hypothesis that if we had actionable remedies in English law for the wider aspects of the convention, we might actually see more immediate action on some of the things that have been called out. What are some of these things? Well, in the last periodic review, the UN committee found some quite damning issues relating to the use of exclusion. They essentially suggested that the experience of people from ethnic minority backgrounds in England is significantly worse in the education system than children from other groups. And as somebody who is part of one of the groups who have been said to have been treated unequally in education, particularly Black Caribbean students, I would like to see action more quickly on addressing these really big, totemic, important issues. And it seems as though there's less of an incentive to resolve these things without an actionable, essentially judicial review ground, which is what I believe might be generated by the creation of that Children's Rights Act 2022. I suppose the final aspect that I'd like to raise relates to some work that colleagues at the University College Belfast have been doing around how we have a very narrow concept of how we empower children and young people in this country. A series of international treaties have suggested that we should teach and promote young people the values of education, citizenship, and human rights, but that we should also treat them in a way that is compatible with those principles and enable them to take action where that's not being recognised. I think that with a remote international treaty, there is not the possibility of creating that kind of atmosphere and environment in England. However, if there were a cause of action, we would be able to get there. And I think one of the sort of critiques that I have of our current rights framework is that it doesn't seem to provide many opportunities for children and young people as individuals, as people who are children and young people, to have, for example, their freedom of expression as a child recognised independently and distinctly from the more general Article 10 discussion. If we did start to think from a children's rights perspective, in addition to a human rights perspective, we might, for example, start to think about encouraging more use of student councils, internal democracy, actual dialogue between students and the teacher leadership in a school environment, for example. At present, we have a relatively narrow best interest provision that does see some involvement of the voice of the child, for example, court proceedings, but not in many other instances. I believe that a Children's Rights Act 2022, parentheses, England, might get us closer to that position. I'll finish my comments there and look forward to the questions.
Thank you very much indeed, Michael. So we now have 10 minutes before the second panel in which we can take some questions from the audience, and just to encourage you to please post some questions in the Q&A. We'll start with the first question. What can other countries learn from Scotland's experiences of campaigning for UNCRC incorporation, and in particular, how best to involve children in the process? Perhaps I can ask Juliet to respond to that.
Yeah, certainly, and that's a great question. There are a number of different aspects that I think are important. I think involving a broad range of stakeholders, making sure that you've got international comparators, and setting out what difference it's going to make. And these have all been absolutely key to Scotland's campaign for UNCRC incorporation. In terms of involving children and young people, then it really helps to have very active civil society organisations like the Children's Parliament and like the Scottish Youth Parliament, who are really good at working with children and young people. The Scottish Youth Parliament is led by young people themselves. They're really good at going out and talking about rights and about law in language that everybody understands. And I think that helps adults get their head around things as well, because law can be quite scary and legal. You talk about incorporation, or you talk about Section 6. And when it's explained to you by a child or a young person, it's far less intimidating, and it just gets to the nub of what they're imagining and what they're campaigning for. So that's a great way of involving children and young people. But I'd say you also have to do a lot of work involving parents, because you always get the children's rights. What about parents' rights? So talking about how the UNCRC has this vision of kind of children and young people growing up in an atmosphere of happiness, love and understanding, and has the family at the absolute centre of that, is key, so that then parents can see the UNCRC as a tool to advocate for a better life for their child, rather than a threat to their own rights. And I think that follows through as well when you're talking to teachers and social workers and the police. Then they tend to see kind of children's rights perhaps as being punitive, a stick to beat them with. Whereas if you see it as a tool for achieving what you want for children and young people, and frame it in that positive frame, then I think you're more likely to get people's hearts and minds on board. That's the kind of the hearts and minds campaign, but you do have to do the legal work as well. There was a lot of work in Scotland with the legal community. The Children and Young People's Commissioner Scotland worked together to set up an expert advisory group to draft a bill, so we could see kind of technically what incorporation would look like. And Kasey was one of the brilliant members of that expert advisory group. So involve academics in that kind of technical side of things. We're constantly looking out internationally at best practice. What have bills looked like in other countries, in Norway, in Sweden, in Finland? What impact have they had? And so where can we take examples? And yet finally, what difference it will make? Every day, case studies from children and young people as to what they think their schools would look like if people understood their rights and respected their rights, their families. But also how things have changed in the international sphere, particularly in relation to kind of, I think justice is where it has made a big difference in Norway, for example, and cases around asylum and migration, which fall out with the competence of the Scottish Parliament actually, but they still show in practice what change incorporation can make.
Thanks very much indeed, Juliet. Moving on to another question. This one I think I'll put to Michael. Have you perceived a shift over time in how a new generation of children see the UN Convention on the Rights of the Child, and in turn how they see human rights more broadly?
Yeah, this is really interesting. So this issue has quite literally followed me throughout my entire career, and I have watched with great admiration, in essence, the total perseverance of generations of the Scottish Youth Parliament keeping this on the agenda and making sure that decision makers were aware that this was something that was deeply felt and widely felt by a very broad base of Scottish young people. And I as an observer in the children's rights and participation space, have seen very little in terms of the beliefs of the people who are polled in the Make Your Mark surveys and things like that around this issue. It's still always been very popular. But what I have seen, and certainly this is something that I picked from Juliet's comments, there has been quite a lot of adaptation of the methods that campaigners, especially young campaigners, have used in order to get this. And I used to see some stickers and posters and some fairly traditional types of visible physical campaign identities represented around yeah, I think we once had an action around the Holyrood area, and then people might have put a few up for politicians to see. That was a very, very long time ago, and since then, my social media feeds have been buffeted by all manner of really inventive videos and some flash mobs and direct actions that members of the Youth Parliament have committed over there. And I'm just blown away by, well, on one hand, the resilience, and the other, the creativity. And I suppose the other aspect of the question is the fact that it's been kept on the agenda so long by so many successive generations has really impressed me.
Thanks very much, Michael. Question now for Kasey. Kasey, the Supreme Court judgment was predictable in the eyes of many constitutional lawyers. Was the Scottish Parliament aware of the devolution issues which those provisions raised? Was it addressed by the law officers and/or in debate in the Scottish Parliament?
Yes, is the simple answer. I mean, there were extensive discussions about the different devolution issues. I think, well, I'm not going to speak to politics. I think that always probably grinds people the wrong way with the American accent. But I think that there were extensive discussions about the various devolution issues. And the hope was that, in fact, the interpretation under Section 101 of the Scotland Act was going to be acceptable in terms of reading things narrowly. You know, obviously there's a little bit of political tension there in terms of the outright, let's strike down acts of parliament when they're not compliant, which, you know, I think there are lots of different views on that, but I think it is something that has to be resolved. But there should not be any confusion. There were extensive discussions, not only in Parliament, but along the lines of the Scottish Government's drafting committee and all of the different feed-in. As Juliet said, there have been so many people feeding into this process, experts on children's rights from international experts, you know, QCs, lots of legal opinions were sought. So it's something that was discussed ad nauseum. In fact, far more than what it would be like to actually implement the different rights of the convention, because that is something that the Scottish Government and most of the proponents of the bill were very confident that that can be done. And in fact, work is still going on with that, which is really heartening. All we need now is that, that stick and carrot in the law. So, but definitely it was discussed.
Thanks very much indeed, Kasey. It's a perfect segue to our second panel, which we're now going to move to. And our second panel is going to consider these wider questions of the implications of the judgment for the devolution settlement and broader questions of the human rights framework in Scotland. So taking a more constitutional position in reflecting on the significance of the judgment and what's going on. So I'd like to move now then to introduce the second panel. It comprises Dr. Chris McCorkindale from the Law School at the University of Strathclyde, Alison Byrne from the Scottish Government, who is the Interim Director of Equality, Inclusion and Human Rights, and Professor Alan Miller, who I mentioned earlier, from the Centre for the Study of Human Rights at Strathclyde, and who was independent co-chair of the National Taskforce for Human Rights Leadership. Over to you, Chris.
Okay, thank you. I'll just bring this up. Okay, so yeah, I don't really intend to talk much at all about the bill or about children's rights so much as to talk about some of the wider implications, the constitutional implications that arise from the judgment, and that obviously feed back into how discussions around the reconsideration of the bill might go. So I've asked a few questions and I might not offer much in the way of answers to those, but at least it will flag up some of the ambiguities and areas of controversy or resolution that the judgment leaves behind. So the first one is, what might the judgment mean for the limitations on devolved competence? Limits to devolved competence are found in the Scotland Act 1998, Section 29, read together with Schedule 4, which details the statutes that are protected from modification by the Scottish Parliament, and Schedule 5, which details the policy areas that are reserved to Westminster. Schedule 4 protects, with exceptions, the Scotland Act itself, including 28.7, which we'll come to discuss in a moment, from modification by devolved legislation. So what is Section 28.7 of the Scotland Act? Section 28.7 of the Scotland Act says that this section does not affect, nothing in the Act affects the power of the Parliament of the United Kingdom to make laws for Scotland. So regardless of the generous devolution of policy and lawmaking powers to the Scottish Parliament, the sovereign right of the UK Parliament to legislate for Scotland is unaffected. Now, traditionally, that's been understood as something of a symbolic restatement of Parliament's continuing sovereignty. It's putting parliamentary sovereignty into legislative language. So when we look back at the debates about the Scotland Bill or about the Government of Wales Bill, as Welsh devolution was being debated, we see a very clear view of what Section 28.7 and this restatement of parliamentary sovereignty is about. So the Government of Wales Bill, when it was being debated, it was argued that actually no such provision was required for Wales because parliamentary sovereignty was such a constitutional fundamental that it didn't need to be restated in legislative language, okay? That it would endure regardless of its restatement, and so the provision would effectively be meaningless. We saw in the Scotland Bill another argument that what Section 28.7, preserving the right of the UK Parliament to legislate in devolved areas, would do is it would send a symbol to and a signal to devolution sceptics that what was being brought about was a devolved settlement where sovereignty is retained at the centre, not, for example, a federal arrangement where sovereignty is shared between the devolveds and the UK, and which creates very strict limits on devolved autonomy. Now, if that was the traditional understanding of Section 28.7, this symbolic restatement, this signal of Parliament's enduring sovereignty, in recent case law, we've seen a kind of shift away from that understanding where the Supreme Court actually attempts to create from that symbolic provision to reconfigure a more robust justiciable limit on legislative competence. So in the Continuity Bill reference, which resulted from the implications of Brexit, Section 17 of the Continuity Bill would have required UK ministers to seek consent from Scottish ministers to act in devolved areas where they've been enabled to by the UK Parliament. The Continuity Bill reference, the Supreme Court said that would condition, it would qualify the unqualified power of the UK Parliament to legislate in devolved areas, which it defined more broadly than parliamentary sovereignty. Right, so parliamentary sovereignty as a constitutional fundamental is not necessarily what's contained in the Supreme Court's view in Section 28.7. Rather, it's a broader unqualified power to legislate. And so if we require UK ministers to seek the consent of Scottish ministers even when acting under the authority of UK legislation, we are somehow conditioning the unqualified power of the UK Parliament to legislate. And that's what was built upon and expanded, I think, in the UNCRC bill reference. Section 19 of the UNCRC bill requires courts to interpret UK legislation narrowly or broadly in order to be compatible with rights, even if that changes the intention of Parliament when it legislated. And Section 21 of the UNCRC bill would have allowed courts to issue declarations of incompatibility, not to strike down legislation, but to state that the legislation is incompatible with convention rights and to play the ball back to the UK Parliament to do something about it if it so chooses. The argument of the court was that both of these provisions qualify the power of the Parliament, of the UK Parliament, to legislate in Scotland, because interpretation allows courts to change the meaning and the effect of UK Parliament legislation, and because declarations of incompatibility impose pressure on Parliament, the UK Parliament, to avoid the opprobrium of the incompatibility. Now that's where the Supreme Court has taken us, but it leaves some constitutional controversies behind it. For example, both sections 19 and 21 are modelled on the Human Rights Act model. They're modelled on Section 3 in the interpretive obligation in the Human Rights Act, Section 4 in the power of to issue declarations of incompatibility that are themselves thought to be consistent with parliamentary sovereignty. It challenges the way in which we traditionally think about that compatibility, because Section 4 is thought in particular to be compatible with parliamentary sovereignty because it doesn't require a legal response from the UK Parliament. The courts state that there's an incompatibility with rights, or in Section 21, an incompatibility with children's rights, but it leaves it to the UK Parliament to decide how, if at all, to legislate. Well, here the Supreme Court has said that political constraints, political pressure, might lead to legal bite, and that in itself, that political constraint constitutes a qualification on Parliament's right to legislate for Scotland. And then what does it leave behind for ordinary judicial reviews and other constitutional situations that place political pressure on UK? Can we say that ordinary judicial reviews place limitations on the right of the UK Parliament to legislate for Scotland? I think that would probably be a stretch too far, yet it fits within the logic of what the Supreme Court has said. Next, I'll just throw up another question about devolved competence, which is in the way in which the Supreme Court frames this. There's a long quote here, which I won't read, but essentially what the Supreme Court says is that in terms of the unqualified right of the UK Parliament to legislate for Scotland, it's not only positive acts, it's not only the positive act of legislation that counts, but also the decision of the UK Parliament not to legislate, not to use that power, is itself a decision, and itself constitutes a way in which Parliament exercises the power to make law for Scotland. So we now have an idea of not a complete devolution of power to Scotland, limited where Parliament actively seeks to legislate, but potentially with limits where Parliament decides not to legislate. And so what I think we've got is a new constitutional limit to devolved competence, the way in which the court has interpreted Section 28(7, and to a certain extent, a space for the Scottish Government and Scottish and UK Government to speak past one another in terms of what has been devolved. Has the devolution of the statute been complete, or is it somehow conditioned by Parliament's decisions whether or not to legislate in devolved areas? Now, there's two more questions that I'll just raise here. What might the judgment mean for pre-enactment scrutiny? UNCRC Bill Section 6 said that it would be illegal for any public authority carrying out any function to act incompatibly with the UNCRC, that maximalist approach. And the Scottish Government argued that, well, on the face of it, that might clearly apply to UK public authorities exercising reserved functions, but that would be saved by a general obligation in the Scotland Act, Section 101 of the Scotland Act, to interpret Scottish legislation narrowly so as to bring it within devolved competence. In other words, we don't have to worry about this applying to UK public authorities carrying out UK functions, because the courts will just narrow the definition of the Act on a case-by-case basis. Now, that was deemed to be unsatisfactory by the courts, that it drew the courts too closely into determining the limits of legislation, which should have been a matter for the Parliament and for the government. But what I think it raises is some general issues. So pre-introduction scrutiny of any bill proceeds in Section 31 with a statement by the responsible minister and by the presiding officer that legislation would be within legislative competence. Pre-enactment discretion to refer doubts about legislative competence to the Supreme Court by the UK and Scottish law officers. And in practice, pre-introduction scrutiny conducted by the Lord Advocate, by the Advocate General, and by the presiding officer in the 3 weeks prior to introduction to clear up any of the issues that require to be resolved before it gets to that reference stage. Now, there was only one Scottish Government bill that's been introduced with a negative statement by the presiding officer, 3 that have been introduced and then referred to the Supreme Court by the Advocate General, but that doesn't tell the whole story about the extent of disagreement and how that's resolved. And a significant feature of pre-enactment checks is assurance by the Scottish Government that Section 101, the interpretive obligation, the requirement to interpret legislation narrowly so as to be compatible with the devolution settlement, can save provisions that on their face might appear to be outside of legislative competence. But that raises 2 problems. One of transparency. The government can introduce legislation knowing that the legislative output, the impact of the legislation, is quite different to the promise that it makes as it introduces it into the Parliament. And one about dialogue, these iterative discussions between these pre-enactment checks that check for legislative competence, because the bill is not sufficiently defined and its legal impacts are not sufficiently defined for those dialogues, for those iterative processes to be meaningful. And so you see in the UNCRC reference here, section 101 cannot have been intended to be construed as having the effect of rendering nugatory the pre-enactment safeguards provided by the Scotland Act. Greater precision is needed on the part of the government and on the part of drafters, and more robust scrutiny is needed of that precision in order to ensure legislation is within legislative competence. And then I'll just ask one final question, the elephant in the room. What might this big devolution judgment mean for the legality of an independence referendum, a unilateral referendum bill, assuming that the UK government doesn't play ball and issue a Section 30 order? How does that change the game as to whether a unilateral bill would be legal or not? Well, in order to be legal, the bill would be outside of legislative competence if it relates to the reserved matter of the Union of the Kingdoms of Scotland and England, reading 29 and Schedule 5 together. And the test is determined by the purpose of the provision or the purpose of the bill, having regard, amongst other things, to its effect in all the circumstances. Now, it's been argued recently, even from surprising sources. I've listed here Adam Tompkins, a former Conservative MSP, who is not predisposed to independence and who previously said that such a bill would be outside legislative competence. If the government presents an independence referendum bill as if its purpose is to seek the opinion of the Scottish people, knowing that its effect in law is zero as a result of the Miller judgments on the legal effect of the Brexit referendum, it's going to be difficult, says Adam Tompkins, to conceive of to convince the Supreme Court that the measure relates to reserve matter. But I do wonder about this. Initially, I thought the bill had no impact on the referendum debate. But on a second reading, looking at the argumentation around the political pressure that's put on the UK Parliament to respond by a declaration of incompatibility, I wonder if that will influence the effect in all the circumstances of a referendum bill. Whereas we saw in 2016, in the aftermath of the 2014 referendum, that even a no vote put pressure on the UK Parliament to respond legally with the Smith Commission and the production of the Scotland Act 2016. So I think I'll just leave that there and I'll look forward to any questions you might have about that.
Chris, thank you very much indeed. We're going to move straight to Alison to make sure everyone has their 10 minutes. So Alison, over to you.
Thanks very much, Murray. Good evening, everyone. I just wanted to start by thanking the organisers for inviting me here today on behalf of the Scottish Government, and I've enjoyed listening with great interest to the contributions today on what is a really important topic at a pivotal moment for Scotland as we make progress on a challenging and ambitious human rights agenda. I'm really struck by the language, actually, particularly that Juliet used around hopes and dreams and ambitions, and that feels absolutely central to what Scottish ministers are trying to achieve in this space. I'm still new in my role as Interim Director for Equality, Inclusion and Human Rights in the Scottish Government, so I am ably joined today by my colleagues Elizabeth Campbell and Liz Levy, who can answer any more detailed questions that you might have. Elizabeth's the Deputy Director for Human Rights, and many of you will know her from the National Taskforce on Human Rights Leadership, and Liz Levy is head of our Children's Right team, so welcome to them both as well. And they'll be able to answer any questions that you might have later in the panel. So a number of speakers this evening have given some really helpful insights into the UK Supreme Court's judgment on the UNCRC bill, and Chris has just talked through there some of the complexities of the legal response and what all of that means. So I thought I would offer just a short update this evening on the Scottish Government's response to the judgment, and then move on to talk a little bit about the broader human rights bill that we're progressing at the moment in that context also. So I think as Chris has actually set out, the judgment raises a number of complex issues for the bill and the wider devolution settlement. And those complexities do require careful consideration, as you would expect. However, the Scottish Government does want to ensure that the incorporation of the UNCRC happens as quickly as possible, with a high degree of confidence that any amendments to the bill don't attract further challenge, and we're continuing to work through the implications of the decision at this point in time. But as Juliet Harris mentioned earlier in her presentation, to allow incorporation of the UNCRC to the fullest possible extent as soon as is practicable, the Scottish Government's preference is to address the Supreme Court judgment by returning the bill to the Parliament via the parliamentary reconsideration stage. And colleagues are currently considering carefully how to do that so that we deliver UNC incorporation to the maximum extent possible, whilst also addressing the Supreme Court's decision and minimising the risk of further challenge. It's clear that Scottish ministers still want to deliver a revolution in children's rights in Scotland, so please be assured that while these considerations are ongoing, the majority of work in relation to the implementation of the UNCRC can proceed and indeed is continuing at pace. As soon as it's possible to do so, we intend to present the proposed response to the Supreme Court judgment and invite views from targeted stakeholders to a small number of questions that will focus generally on the technical means by which we propose to effect incorporation to the fullest extent possible in light of the judgment, but we will not be revisiting the broader principles of the model of incorporation. The purpose of targeted engagement then will be to help make sure that, in light of the judgment, our stakeholders and partners are confident that the proposed route to incorporation doesn't diminish our commitment to incorporate to the maximum extent possible. So turning now to the implications of the UNCRC on the Human Rights Bill, the multi-treaty basis of the Human Rights Bill and the interlinkages between the various treaties add another layer of complexity that will necessitate an approach which complements but does not necessarily duplicate the approach taken on the UNCRC bill to incorporation. It remains the Scottish Government's intention to consult on the bill in coming months and to introduce the bill in this parliamentary session, as ministers have publicly committed to do. And although we are considering in detail any implications of the judgment on the Human Rights Bill, we remain fully committed to that work, which I'll turn to outline just in a wee bit more detail. So I'm sure you're all aware of the background to the work and the National Taskforce for Human Rights Leadership publication in March 2021, co-chaired by Professor Miller, set out their recommendations and evidence base for establishing a new statutory framework in Scotland. The 30 recommendations from the task force are bold and ambitious and build on previous work, such as recommendations of the First Minister's Advisory Group. They also complement ongoing human rights work, such as the development of our equality and human rights mainstreaming strategy and work on access to justice to help put Scotland firmly at the forefront of human rights leaderships. And ministers have committed to take these recommendations forward in the Human Rights Bill. You will all know that the bill will incorporate into Scots law, so far as possible within devolved competence, a wide range of internationally recognised human rights, including those set out in the International Covenant on Economic, Social and Cultural Rights, alongside the Convention on the Elimination of All Forms of Discrimination Against Women and the Convention on the Elimination of All Forms of Racial Discrimination, and also the Convention on the Rights of Persons with Disabilities. In addition, the bill will include a right to a healthy environment for everyone, a right of older people to ensure equal access to their human rights, and an equality provision to ensure equal access for everyone, including LGBTI people, to the rights in the bill. So this comprehensive framework will ensure that protecting and progressing these rights will be a central, fundamental part of the decisions the public sector will make in Scotland. It will also empower people, whatever their circumstances, enabling to claim and enforce their rights in multiple ways domestically, including in a Scottish court. While we're still developing the bill, which you'll appreciate is an extensive process, we believe that sharing responsibility among different actors will ensure that a culture of human rights thinking, which is something that Juliet referred to earlier, is embedded across the public sector. We believe the bill should make it easier for people to hold duty bearers to account. We're working with a wide range of partners and stakeholders across Scotland and are being provided with lots of examples of where the bill might improve individuals' lives, and we're building those into our work. We've seen the breakthrough cases that progress civil and political rights since the introduction of the Human Rights Act 1998 and want to ensure that this Human Rights Bill has the same progressive impact for individuals' economic, social and cultural rights in Scotland. I just want to turn now and talk a little bit about public participation, because it's a key point that's been raised today by a number of speakers, and the Taskforce report stressed the importance of public participation in the bill process and how the Scottish Government should work with a wide range of stakeholders and partners to inform its thinking in this area. So a priority for us has been to make sure that there is meaningful, ongoing public participation that listens to the voices of those with lived experience and informs the development and delivery of the bill. And I think that's vital if we're going to get this right for everyone. And it is a point that's been made by a number of speakers this evening. So as part of this, we've established internal and external groups to help us through the bill development process. We've put in place a bill executive board, which comprises senior decision makers from across the public sector, and will consider the associated strategic resource and capacity building implications of the bill. The bill advisory board is also now in place as part of the commitment to public participation, and is a forum for key civil society partners to raise issues and contribute to the development of the bill. The Taskforce report also emphasised the importance of a human rights-based approach to public engagement, and as part of that approach, of course, we recognise that barriers to accessing human rights fall disproportionately on specific rights groups, which has been particularly highlighted during the COVID pandemic. And these groups have a role at the heart of developing this bill, and we've been working closely with stakeholders to help inform how best we can engage with and hear from those with lived experience. So to that end, we're currently working with the human rights civil society stakeholders on a lived experience board for the bill. We're working with the Human Rights Consortium Scotland and the Scottish Coalition for People with Learning Disabilities to ensure that we're maximising meaningful, positive participation for the people taking part in this work. In addition, we're working to establish another work stream of the board that will enable participation for children and for young people. We've welcomed the offer from a number of stakeholders to support our work on the consultation, including the development of alternative formats such as BIICL and Easy Reads, and planning in-person and digital consultation events too. And we're ensuring that we listen to and learn from their feedback to make the consultation as accessible as we can. I think it's probably important though to emphasise that the consultation and the boards and the public participation work that I've outlined will of course not be the only ways to feed into the development of the bill. While that work's underway, we're continuing to collaborate with other partners and stakeholders, and we're looking for wider participatory input going forward. So before I close, I just wanted to touch on the Human Rights Act reform at a UK government level at the moment, and just highlight that we're mindful of the recent announcements by the UK government about the Human Rights Act that could have potential implications for the work that we're taking forward in Scotland. Now, I guess it's important to say that Scottish ministers have repeatedly made clear that they will robustly oppose any attempt to undermine or weaken the Human Rights Act, that those rights are at the heart of the devolution settlement, and ministers have been clear that no changes affecting Scotland should be made without the explicit consent of the Scottish Parliament. So at present, the Scottish Government is working on its formal response to the consultation, which it will provide to the UK Government by the deadline of 8th of March. And we're engaging closely with Scottish civil society organisations as part of that process. Officials also engage regularly with counterparts in the Ministry of Justice and other devolved administrations, and will continue to do so over the upcoming weeks and after the formal consultation ends. Once the UK Government's response to the consultation is known, Scottish ministers will consider what further action engagement should be undertaken to protect existing rights and to ensure the Human Rights Bill can extend and indeed develop the human rights safeguards that apply in Scotland. The Scottish Government is committed to extending and protecting human rights safeguards, and Scottish ministers have made clear they would oppose any attempt by the UK Government that seeks to threaten or undermine its commitment to human rights. So I think that's brought me to the end of the various points I wanted to make this evening, and thank you again for inviting me to speak, and would welcome any questions or thoughts that you might have in the Q&A session that follows.
Thank you very much indeed, Alison. There is a question waiting for you in the Q&A, but before we reach that, we're going to go on to Alan.
All right, thanks very much. In the interest of time and to enable a question and answer session, I'll strip back my presentation and talk faster than usual. Apologies in advance, and try and offer very briefly some personal reflections on Scotland's human rights journey to date, where we are now, including the impact of the Supreme Court judgment and the likely future direction of travel. In doing so, I find a common thread running through all of my experience as a traveller in Scotland's human rights journey for, I have to admit, nearly 4 decades now, that Scotland's constitutional status and its human rights journey are demonstrably and inextricably linked. The judgment placed in this broader context simply serves to reaffirm this. Although it clearly needs to be carefully managed, the Supreme Court judgment on the UNCRC bill is, in my view, rooted in the past, and so will not define the limits for the future. And indeed, its impact is actually more likely to be that of helping to focus debate on the next steps on Scotland's human rights journey. It will inevitably give rise to debate on how further continued human rights progress is to be made in and by Scotland, and particularly in those significant and current constitutionally reserved areas of public life, such as equality, employment, asylum and immigration, and parts of social security. Let me spare you then, in the interest of time, the details of my personal involvement in this human rights journey and offer a summary that essentially Scotland's human rights journey, particularly over the last 20 years of devolution, has been marked by an increased confidence and ambition and internationalism, and that this has been clearly reflected across the entire political spectrum, the public sector and civil society, and indeed was evidenced in the unanimous vote in the Parliament for the UNCRC bill. So we're now on the cusp of the biggest step by far on the journey, and will for the first time put in a single place the internationally recognized human rights belonging to everyone, as well as a means of effective implementation to enable full and equal enjoyment by all. The bill, very, very briefly, will incorporate ICESCR, CEDAW, CRPD, CERD, obviously UNCRC will take its place in the framework, as well as include the right to a healthy environment, the rights of older people, and equality rights for LGBTI people. What then will be the short-term impact of the Supreme Court judgment? On the one hand, and it's a significant hand, the judgment essentially reaffirms that human rights are not reserved to the UK Parliament by the Scotland Act, and that Scotland is free to incorporate UN treaties. On the other hand, and it is significant too, its interpretation of the Scotland Act arguably gives an increased weight to the historical doctrine of the supremacy, or now unqualified power, of the sovereignty of the UK Parliament, and this has come to be widely critiqued, including beyond Scotland. In its assertion of such unqualified power, and perhaps of most immediate practical significance, the judgment appears to require the Parliament to revise the bill in order to explicitly limit its scope in relation to the human rights duties applicable to those public authorities in Scotland which carry out mixed functions in both devolved and reserved areas. However, the judgment is what it is for now, and we therefore clearly need to be agile, innovative and pragmatic, whilst adhering to principle and the maximalist approach of the bill to revise the UNCRC bill and then draft the human rights bill accordingly. What, however, is the broader UK context and the broader context of the proposed human rights framework for Scotland and the longer term impact possibly of the Supreme Court judgment? As far as possible, the Taskforce attempted to future-proof its recommendations for the bill. Firstly, we reflected the devolved reserve dimension that is highlighted in the judgment in the Taskforce report, with language throughout its recommendations emphasising that the recommended promotion and protection of human rights needed to be within devolved competence, and this was in order to manage expectations. Secondly, recent Supreme Court judgments, in addition to this latest one, also appear to reflect a reduction in how the court regards the status of international human rights law within the UK. And indeed, this is evident in some of the legislation going through the UK Parliament just now, and in continued undermining of the Northern Ireland Protocol, an international treaty in itself with real human rights implications. So this has underlined the need for Scotland to incorporate a range of UN human rights treaties into its law policy and practice to the maximum extent possible. Thirdly, the recent announcement of the intention of the UK government to repeal the UK Human Rights Act, even though it is hardwired into the Scotland Act and the broader UK devolutionary framework, and to replace it with a British Bill of Rights, will lead to a further reduction of the level of protection in those reserved areas, notwithstanding the opposition to the repeal of the human rights from the Scottish Parliament. The Taskforce report implicitly anticipated this possibility by recommending that Scotland's Human Rights Bill explicitly restate the rights of the Human Rights Act so that they would at least continue to apply in devolved areas as far as possible. I'd like to say a few words about the two human rights trajectories within the UK. I think the cumulative effect of all of these developments is that we will increasingly experience two different human rights trajectories taking place in the UK. This will, I think, be felt most acutely in Scotland, where, broadly speaking, one will be progressively realising human rights within devolved areas, and the other trajectory will be reducing human rights protection in reserved areas. And the judgment and the pending Human Rights Bill are likely to draw more attention to this dynamic and impact on people's lives of these two trajectories, and therefore stimulate debate about what needs to be the next steps in Scotland's human rights journey. I think the long-term effect of this judgment will be that a growing appetite in Scotland develops, and that human rights need to be protected and promoted equally across devolved and reserved areas, so as to improve all aspects of the lives of everyone. There will, I think, be an increasing desire for greater legal certainty and consistency of applicable human rights standards of public services across devolved and reserved areas of public life. As I said at the outset, the nature of the next steps in Scotland's journey will, I think, be dependent largely upon any further developments regarding the constitutional powers, therefore, of the Scottish Parliament, in terms of any enhancement of its powers in at least some of the currently reserved areas, or if through independence, its ability then to enact a Bill of Rights, unlimited in scope and entrenched within a written constitution. The Taskforce report also recognised this potential and included it within its recommendations. Of course, we have to focus on the here and now, the UNCRC bill, the drafting of the pending Human Rights Bill. But it would be a mistake, I think, not to lift our heads and look to see what might be the requirements and the landscape with future developments. In conclusion, I think from a human rights perspective, my personal experience from Scotland's journey to date and work with the UN over the past few years, where there is this also perception of two trajectories in the UK, is that in these times it's not possible for any of us to stand still, or we will inevitably regress. We need always to be looking ahead and be ambitious for further progress, and therefore remain firmly on an outward and forward-looking trajectory. I have to say, fortunately, while serving as chairing on a co-chair basis of the task force, I did find an increasing ambition held by an increasing number of people from all walks of life and all parts of the country, and in particular, a determination post-COVID to build back better, placing economic, social, cultural, and environmental rights at the centre of all recovery efforts. And this, I think, is grounds for optimism that there is a will to navigate our way beyond this judgment. So I hope these very hasty personal reflections of a traveller has demonstrated that although clearly this judgment needs to be carefully responded to on the bill, it is rooted in the past. It cannot define the limits for the future, and indeed its impact, ironically, is actually more likely to be that of helping to focus debate on the next steps on Scotland's human rights journey. Thanks very much, Murray.
Thanks very much indeed, Alan. One of the things we'll find out down in London is over the next few months is exactly how regressive that trajectory that you've described is going to be. The consultation paper does contain some quite outlier proposals, and it remains to be seen to what extent there's going to be consensus to support those in some important places, including in the House of Lords at Westminster. So there's a lot still to be decided there. But thank you very much indeed, Alan. We've got very little time left, and we do have some questions. So I'm going to move straight to the questions, if I may. Alan, you've actually I think given your view on the first question, but it may be that Alison would like to answer this one. Do the panel have any thoughts on the impact that the proposals regarding public authorities in the government's Human Rights Act consultation might have in Scotland? For example, in terms of limiting the definition of public authorities, or the government's concerns that positive human rights obligations are getting in the way of public service priorities. So a specific question about the part of the consultation paper about the definition of public authority. Alison, I don't know if you'd like to have a go at answering that.
I might ask my esteemed colleague Elizabeth just to come in on that one, if that's okay, Murray.
Absolutely.
Thanks, Alison. So I'll just try and rattle through this quite quickly, given we've only got a few minutes left. But, you know, as you would all expect, we've been following the UK government proposals on the Human Rights Act very, very closely and very carefully. And I think our ministers have been very clear that we robustly oppose anything that will undermine or weaken the Human Rights Act, and any attempt to do that. Our Deputy First Minister did write to the Lord Chancellor in December on that basis. And, you know, we really recognise that any change to the existing statute would be a constitutional matter with specific and direct implications for the exercise of both legislative and executive competence by devolved institutions. So I don't want to sort of say anything really specifically about the question around limiting public bodies, because we're working through all of the consultation proposals at the moment, and there will be a Scottish Government response to all of that, and it will be quite lengthy and very carefully thought out. So, but yeah, any attempts to weaken the provisions in the Human Rights Act, you know, we absolutely will not accept.
Thanks very much, Elizabeth. Question perhaps, Chris, or sorry, Alison, did you want to come in? No. A question perhaps for Chris or Alan from Richard at Bonavero. Considering the court's reasoning in the Supreme Court's decision on the Incorporation Bill, I get the impression the court views parliamentary sovereignty as a trump card on everything. Is that correct? Or is the court perhaps going a wee bit too far about how significant parliamentary sovereignty is, perhaps conflating it with supremacy, particularly when comparing it to other matters concerning the Constitution, such as separation of powers, rule of law, protection and promotion of human rights? Chris.
I don't know if I would say that the court is pushing parliamentary sovereignty too far. I think they take the notion of parliamentary sovereignty seriously, but there is something that's going on within the court at the minute and its jurisprudence which goes beyond devolution and which goes beyond the UNCRC reference, which is an attempt to construct a legal scaffolding around the political constitution. So we've called this, myself and Aileen McCargan and various bits of writing have called this a kind of radical conservatism, that the judges are doing something radical, but they're doing it to protect traditional conservative aspects of the political constitution. So you see ouster clauses being struck down on the justification that they limit the role of Parliament. You see prorogation undone on the basis that they limit both the accountability and legislative functions of Parliament. You see the Continuity Bill reference and the UNCRC Bill reference use the unqualified legislative power of Parliament in order to strike down devolved legislation. So that it looks to me like there's a pattern of something that's going on here, where not just about parliamentary sovereignty, but where the court is trying to legalise the outer limits, the boundaries of the political constitution, and that's leading in quite radical directions with regards to ouster clauses, prorogation and devolution cases. It's changed the nature of the jurisprudence. But it's important to say that the court was quite inconsistent on parliamentary sovereignty in this case, because at times when they talk about the Human Rights Act and how that compares to the UNCRC bill, they're talking in language of parliamentary sovereignty. But at other times they're at pains to distinguish parliamentary sovereignty as a principle with section 28.7, which they say relates to something slightly different and slightly broader, the unqualified power of the Parliament to legislate for the UK. So are they pushing it too far? I think in the devolution case, they've done something different than what was intended by Parliament in 1998. And I think that fits into a broader scheme of this, what I call radical conservatism, building legal scaffolding around the political institutions.
Thanks, Chris. Alan, did you want to come in on this question?
No, let's move on, please, Murray.
Chris, just as a footnote to what you've said and picking up on something Alan commented upon, I think we see it also in relation to the Supreme Court's approach to international law generally, and the domestic status of international law, and a return to a sort of hyper-dualist approach. And interestingly, it's quite contrasting with the House of Lords, the legislative House of Lords approach to the UK Internal Markets Bill. And the provision in there, which on its face would have been in breach of international law. And the House of Lords very robustly made clear that it just would not wear that as part of the legislature. It did not want to be involved in or implicated in a breach in legislation of international law, which is quite an interestingly different approach. We have one more, I think, time for one more question, if I can just pose it quickly. Why 20 years on from devolution does the panel consider UK law officers have chosen to resort to section 28(7) to protect Parliament from political pressure, after several cases where law officers and indeed Supreme Court justices have focused on explaining the devolution settlement in clearly legal terms? I don't know if anybody would like to have a quick go at answering that.
Well, part of the answer, I think I would refer back to what I think is going on more broadly, which is that there's there seems to be an attempt to, I think the answer referred to fragility of parliamentary sovereignty, but I think it's also about fragility of the political constitution more generally in different contexts. One of the ambiguities that's left behind is well, first of all, it maybe causes ambiguities because the Supreme Court ties itself up in the knot of its own logic when it gets to how these things interact with statutes, so how parliamentary sovereignty interacts with section 28(7) and with the devolution settlement more generally. Now, why law officers are referring bills on these grounds and making these arguments now, I couldn't speak for the law officers. Part of me thinks, why not? You will construct arguments and leave little hangers for the court to be able to hang its jurisprudence on along the way, and that seems to me just part of the cut and thrust of litigation. But I think there might be a more general sense. I've certainly heard this from government sources that the current government views the generous nature of the devolution settlement in Scotland as a mistake. I think that was communicated to the Welsh government during the process of building a reserve powers model in Wales, and there's a more robust view from the UK government about how to stand up, how to defend its competence, if you will. So taking a more aggressive view proactively towards intervention in devolved areas. So we've seen the kind of narrowing of the Sewell Convention. We've seen a more proactive use to the reference procedure, but also to standing up to devolution at the boundaries as well. So I think there's a culture there of a UK government that is probably the first UK government that's really sought to push back on what it sees as a one-way direction of travel in devolution in towards its turf, if you will.
Thanks very much indeed, Chris. We've shot over time, so unless any other panelists wanted to come in on that question with something burning to say, I can't see anybody wanting to. I think it's time for us to wrap up and say thank you very much indeed to all our panelists. It's been a really, really interesting and insightful discussion. So many thanks to all of you. Thanks to the participants as well for the interesting questions. We shall wait with bated breath to see what happens with the consultation, which is ongoing on the UK human rights framework, and what happens with the consultation on the Scottish human rights framework. It's going to be a very interesting and eventful year. Thank you all very much indeed.